Swayam Prabha. Digital India. Educated India.
Dear students, and we will discuss in this particular class market allocation and IPR, and how the market allocation is affecting the competition in the market. So, whether the patent holders or patent owners are using their intellectual property to control the geographical market, whether it is a stores, big stores controlling the dividing the geographical market and putting conditions, unnecessary conditions on the distributors or the retailers, or we will see the different examples, even some of the cases in the study materials. So, you combine together, you purchase some of the very good study materials and then you increase the prices. So, the court have ruled these kind of activities. So, market allocation is one of the very important part of controlling the market, and the competition law taken very seriously into allocation of the markets. So, if any of the companies want to allocate market, that means only this one particular dealer can deal in that particular market and nobody else can do the same business. They restrict it through the different agreements, licensing agreements. Then the court looked into the licensing provisions, whether there is violation of any Sherman Act, violations of any of the provisions of the Sherman Act. In this class, we will look into the market allocation and IP, then some of the horizontal agreements, whether these are affecting the competition law. The first the case of market allocation, and in this case this Hartford Empire Company case versus US in 1945, one of the some early cases. Here the companies combined together to exploit the patents for automatic glass making machinery. These two companies own around 94% of the complete glass manufacturing. Glass manufacturing means not only the glass, but the glass bottles as well. The all materials which are made by the using glass is these machineries, these two companies were responsible. These two companies have the patents for automatic glass making machineries. So, if anybody wants to engage into this particular business, you have to license it this from particular company, this Hartford Empire company. So, here they control 100 patents, this particular company in 1938. Remember, in 1938 they controlled 100 patents, they pulled it together and they cross license, many of the people cross license these particular the technologies, and thus they effectively control the particular market. Remember, intellectual property has not developed as of today during 1938. So, they effectively controlled 100 patents and completely controlled 94% of the market. They controlled the glass containers manufacturing, the Indian glass manufacturing industry in the country was controlled, the machinery was controlled by this particular company. So, here absolutely definitely, if so one company is through pooling and cross licensing controlling 100 patents, they do not want anybody to come to their business. So, the question was whether they are discouraging anybody to come into the market in making glass machinery. At the same time, through these licensing agreement, whether they are allocating the markets, whether these licensing agreements are anti-competitive in nature. The court looked into, these are the issues the court looked into. So, the court looked into and come to the very clearly come to the conclusion that the appellants, individual appellants agreed, conspired, they conspired, combined together to monopolize and restraint, and there is a restraint on interstate trade and also the foreign commerce by acquiring patents. As I told you the earlier class, that patent pools can have a pro competitive effect and an anti competitive effect as well. Here the court found that these patent pools are anti competitive effects as far as the manufacturing of glass machinery, the glass making machinery is concerned, and they are excluding all others from this particular business, and no fair opportunity is going to given to anybody in this machinery manufacturing and distribution of glass products. So, the court finally held that this is absolute violation of Sherman Act 1 and 2 and the Clayton Act section 3. So, because you can see these in the per se we can say that one company is controlling 100 patent, it means that definitely the competition authorities to look into such situations, because until it is going to have a highly pro competitive effect, and the authorities are going to look into this with a suspicious eye of competition law. Here the market allocation is completely happened through the licensing agreements. So, here you can see that these licensing agreements, these completely licensing agreements are with restrictive conditions. These conditions, restrictive conditions, we can find that these restrictive conditions definitely violate the Sherman Act. When we come to another case, that is the Tungan Roller Bearing Company versus the United States, this 1951 case. Here also the civil action were taken against this particular company, domestic corporation, for the alleged violations of the Sherman Act. Here you can the two corporations, they conspired with a British corporation and French corporation to form, so to control again the market. So, what they did, they divided the territorial market all over the world market, and they make bearings, anti friction bearings. So, they divide the whole world market, geographically they divided the particular market. So, the question is, can you sitting in somewhere where the United States or India or it is somewhere in China and control the world market by allocating the particular markets? We will see some of these cases, very interesting cases. Here you can see that every company have a financial interest, and the objective of every company to increase the profits. Whether it is in the domestic market or it is in the foreign market. Now, the markets become very small and everybody is looking into international trade. So, the globe become very small and everybody is exporting their materials, manufacturing. So, here they divided the market, the complete market. So, here the district court found that the agreement between these corporations to allocate trade territories all over the world, which violates the Sherman Act. So, in this here the allocation of territories are happened through these licensing agreements, and they fixed the prices according to the geographical markets. It is not uniform prices. Prices are fixed according to the geographical markets, and they cooperated the licensing agreements. Through the licensing agreements, they cooperated each other to protect other markets and eliminate outside competition. So, other competitors cannot enter into this particular market of bearings, and moreover they enter into cartels to restrict imports and exports from United States. So, the question is whether you do the business within the territories or outside the territories, does not matter. They are going to look into the activities which has happened where any of the violations of the particular provisions. Here the fixing world territories, it is clearly said that it is violated the Sherman Act. So, if there is no trade restraint, then there is no violation of Sherman Act. Joint venture, very well you can make the joint venture, but the objective must be very clear, and the incidental, this is just incidental argument is not going to work every time. And also we can the agencies can look into the decision making of the companies, who is the director and what kind of decisions they are taking. and common ownership and control of different corporations can form cartels. That is why I said if two corporations to form a joint venture, we can understand whether it is a cartel or not, that will be decided by the competition authorities. So, the common ownership and controlling of corporations are also not prohibited, but their activities must be very clear. The competition authorities can very well look into what are the activities of these corporations after and before the merger or acquisitions which has happened. So, if we look into these in the United States, we can find a big supply chain, big stores like whether it is Walmart or Spencer or it is KFC or other marts which we can find in the United States. In this supply chain case in the United States versus Topco Association INC in 1972 case, here we can see that a association of dealers, Topco Association, it is a brand name, this it is a cooperative association of 25 small and medium sized independent regional supermarket chains operating in 33 states of United States. So, and they have large, because they have lot of customers. So, more than 1000 items. So, and it is this brand is always owned by the Topco. So, the conditions are going to be, these are the stores all over the 33 states of the United States. So, always if it is a chain of stores, then definitely the franchising or the licensing agreements are going to be very strict. Here in 1967 itself, their market share was 2.3 billion. So, that means they are fourth, only exceeding 3 other national grocery chains have more than their business. So, definitely they have a market power, market power under the competition law. And also area, so remember average market share is 6% and competitive position is very strong, because it is a chain of stores, and their stock of this Topco stores, common stock, voting stock is also an selection of directors, selection of managers, and they completely control the association operations as well. These stores, these the people those who are involved in this control, they control the activities and taking decisions as well. And the Topco bylaws very clearly says the agreement are exclusive category territorial licenses. Why there is territorial licenses? And Topco says that if there is no territorial licenses, they cannot continue with the business, because too many Topco stores are going to be allowed in a particular region, then the business is not going to be profitable. So, they divided into different geographical markets. It is territorial licenses were issued. So, if membership categories, as I told you, and 2 other membership categories are also there, exclusive membership categories. So, one person cannot sold any product outside this particular territorial market, and expansion of one member to the other member's territory is absolutely prohibited. So, that means if you want to extend your business to the other member's territory, you have to take a prior consent. Prior consent. So, it means that a new member cannot enter into the territory of another member and start business. You require a prior permission of Topco and other members, because the members itself control this particular association. So, here this competition is severely curtailed within the territorial limits, because this association will decide they will make it very sure that this one person is not encroaching upon the territory of the other person. So, the territorial market restrictions are put. Restrictions, Topco put restrictions on wholesale business as well as retail business. Retail business is specifically to that particular geographical area, and the Topco members are completely prohibited from selling any products, so supplied by the association at wholesale. So, and also special permission, they cannot use this trademarked product, Topco trademarked product, without securing a special permission. So, that means without consent, so usually without consent nobody can do business in the name of Topco, and a new member entering into the retail business must agree to the restrictive, so called restrictive licensing provisions of Topco, and Topco product can be only sold in that particular geographical area under the terms and conditions put by the Topco association. So, it means geographically distributed and they operate in all the states, and one dealer cannot overlap into the other dealer. There is a restriction on wholesale business as well. So, all over there is restrictions. So, the market power restrictions are there. Here see dividing markets. So, the government was alleged that this dividing the market was violative of the Sherman Act, because it prohibits competition Topco brand products among grocery items. So, no person can enter into this particular Topco grocery business, where already there is a Topco shop is there, until the Topco is giving a permission. And also there is restrictions on retail as well as wholesale business as well. So, this is a violation of the Sherman Act. This was the allegation, but the Topco contended that the entire business is dependent upon the geographical division, and if exclusive geographical division, if this exclusivity goes, their business are going to be in loss and they are going to lose the business. But Topco brand, as I told you, this is very specifically with regard to the Topco brand. So, the Topco brand enabled the stores to sell these particular products, and these restrictions are necessary to compete with larger stores. These were the justification by the Topco which was raised, but the court held that the Topco scheme of allocating territories and minimizing competition, and virtually there is no competition, and at the retail level as well as at the wholesale level is a horizontal restraint. So, it is per se violation of section 1 of the Sherman Act. And also the court held that the district court has erred in its decision to restrict the practices which is involved in the rule of reason applications. So, Topco's limitation upon retailing, wholesale is per se the violation of Sherman Act. So, even you are selling a single brand, you cannot put restrictions. The market must be competitive. Even the same brand products which you are selling it, the market should be open. So, the conditions which you put dividing the geographical markets are absolutely against the competition law or the Sherman Act. Again, the restrictions are to be tolerated in the name of competing with the larger stores are not going to be sustainable. So, these are going to be increase the competition. The court has never looked into, never accepted that particular argument of Topco. And then areas, the area divisions are also prima facie considered to be per se considered to be violation of the Sherman Act. And then the court, very importantly, the court said that if the members are not adequately promoting Topco brands, you can terminate the members. And most importantly, all this district court judgment is affirmed by the Supreme Court in 1973. So, if you can once you give the franchising, or you are entering into exclusive licensing agreement of any brands, any top brands, any top trademarks, then you have to be very careful. There must be pro competitive provisions, there cannot be anti competitive provisions. We talked about trademark. Now, you will see the copyright, how the copyright protection, intellectual property protection is going to cross with the competition. So, here I have mentioned earlier also about the reading materials. Here Palmer versus BRG of Georgia, this case is 1990 case. Here the respondents BRG of Georgia INC, they as Harcourt Brace legal and professional publications. These are the publication, and these particular people enter into an agreement and exclusive license to markets this another HBJs, that is publishers trade name, they will publish it in the, they will market it in the HBs, this publishers trade name, and at the same time this publisher agreed not to compete with BRG in Georgia, and BRG agreed not to compete with HBJ in outside the state. So, it is a mutual, okay. You do not come here and we will market your products, and so that I have the exclusivity in this particular region, and outside the state you go and market, we do not have any problem. So, this was discussed in this particular case. Here you see, if you look into the transaction, you look into the licensing agreement, here immediately after the parties entering to the agreement, the prices of this course material has increased from $150 to $400. So, it means that more than double. So, whether this violates any of the competition provisions, if two people comes together, so and you fix the prices, very high price, so there is no competition. So, here the course materials, they argued that the price was enhanced by reason of agreement in violation. The main argument, the main allegation was that the prices increased from $150 to $400 are violation of Sherman Act, was a violation of section 1 of the Sherman Act. The district court held that the agreement was lawful because this is a copyrighted material, and the court of appeal affirmed the copyrighted material which you can sell it according to their the price is your price, because the material is a copyrighted material protected by the intellectual property law. So, you can put your own price. So, here, but the agreement, you can see that the agreement, the provisions of the agreement, by dividing the geographical area. So, I am not going to come to your region, but at the same time I am not going to you do not come to my region, I will not come to your region. The provisions, the agreement provisions are revenue sharing formula, the revenue sharing formula to increase the prices, fixing the prices. So, these are very effective in nature, very suspicious in nature, and the prices are gone up. So, the question is whether these are the violation of the Sherman Act, and the court found that by referring to other cases. The agreement between competitors to allocate territories to minimize the competition are illegal. Absolutely, whatever the reasons, whether it is your copyrighted material or whether you have a trademark, it is limiting or allocating the territories for limiting the competition is violation of the Sherman Act. So, TOPCO, the earlier decision, whether the parties split the market, so they are doing the business, they reserve the market. So, these are absolutely in violation of, because the prices are gone up and the conditions of the competition provisions are violated. And more importantly, we can see that by sitting in one country, we know that all the competition provisions, the question is every law is territorial in nature, we know that, but the question is the competition law provisions are extraterritorial in nature. If you do business outside the territory of United States, whether the United States Sherman Act have a control over whatever the activities you do outside your territory. In this particular case, in Metro Industries Agency versus Sami Corporation, this is a 1996 case. Here the Metro Industries is an importer of some of the wholesale kitchenware products from Korea, and Sami is a South Korean exporting company. So, remember this is international market. Can you do an international market allocation whether it is a violation of a domestic law? This is considered by the US authorities. Here these American subsidiaries alleged that the Metro Industries alleged that the Korean design registration system, they allege that the Korean design registration intellectual property protection design registration system, which makes the hollowware producers have an exclusive right to export the particular hollowware design for 3 years. So, the Korean law which permits the hollowware producers exclusive right for a period of 3 years to export this particular products, whether this is a market division and whether this is a per se violation of section 1 of the Sherman Act. This was the allegation. because it gives a 3-year exclusive right to export the hollowware design products. So, this is considered by this court in this particular case. Here, so the registration system is the main allegation was that the registration system was used to the kitchenware importers, the US people. So, these stainless steel steamers from any of the Siamese competitors in Korea, it is not they cannot import because there is an exclusive right. And these particular products, so these US importers alleging that there is a violation of the Sherman Act, because the Korean law which permits a 3 years exclusive rights. Here comes the due principles, the rule of reason as well as the per se rule. So, we will see these two rules, because if you apply these either of these rules, the result will be different. So, the rule of reason which says that the legal approach of rule of reason which says that the competition authorities or the courts where an attempt is made to evaluate the pro competitive effects in the rule of reason, and per se illegal the court need not to apply, but the rule of reason which gives an opportunity of the court or the authorities to look into the competitive features, whether the restrictive business is pro competitive in nature or whether it is anti competitive in nature, and then decide whether the practice should be decided, practice should be prohibited or not, because the authorities will get a chance to decide, but in the per se rule the authorities are not going to get a chance to decide in between pro competitive effect and anti competitive effects. Here ordinarily we can say that if the defendant can defendant can justify or defendant can very well prove the pro competitive effects, then the rule of reason will be applied, because if the facts and circumstances clearly prove that these restrictions are necessary to continue with the business and it is pro competitive in nature, but most of the time it is never going to happen, because if it is a reasonable restraint, then reasonable restraint plus pro competitive effect on the market, then the rule of reason can be applicable. Otherwise, the per se rule is applicable. So, if it is illegal per se, anti competitive behavior, that anti competitive behavior is considered to be per se illegal under the Sherman Act. That means, unreasonable restraint on trade is considered as anti competitive as well as illegal per se under the Sherman Act. So, here the per se rule which clearly says the certain categories of agreements are per se illegal. So, case by case evaluation is not required, and the conditions which you can see that. So, always tend to restrict competition are per se illegal in nature. So, with reference to United States vs. Brown, the another case, the court very clearly said that if the restrictive provisions are there, then it is the per se rule will be applicable, and market allocation agreement is per se illegal, and any restraint on trade it is per se illegal. Then again, in deciding whether to extend the per se rule to the previously unexamined business practices. So, here this according to the words of the court, the practice facially appears to be one that would always or always tend to restrict competition and decreases output, or instead one designed to increase economic efficiency and render markets more rather than less competitive, by referring to the broadcast music INC versus Columbia Broadcasting. So, which rule is applicable? It will give an opportunity for the authorities to look into the opportunity of looking into the case by case basis, whether it is pro competitive or anti competitive in nature. So, here the rule of reason, the plaintiff must establish antitrust injury. The conduct at issue is actually caused injury to competition beyond the impact on the claimant within the field of commerce in which the claimant is engaged. That means, here the rationale should be proved. So, it is in this particular case in favor of Metro, that means, if a particular rule outside the premises which is affecting your market, you can always look into, but which rule will be applicable, the per se rule or rule of reason, you have to look into the type of transactions. In this case, the court held that, concluded as a matter of law that in court there was insufficient evidence in the order of the court concerning the relevant product and geographical market and SAMI's economic power in that particular market. So, you can see that the again in this particular case the court held the rule held very clearly, but certain questions arises where the context of some incident happening outside your jurisdiction. So, the Korean law permits 3 years exclusive exporting. By using your law, can you say that this is against your law? Extraterritorial in nature, extraterritorial application of your competition law. The discussion is very clear. Do you have an applicability of extraterritorial jurisdiction to your competition laws? So, here the Sherman Act is only applicable in the United States. If there is anything happening outside the territory, but there is an effect on your commerce in the United States, then only there is an application of the principles of competition law or the Sherman Act. If the Korean registration system permits something, you do not have any jurisdiction, but the competition level, at the competition level, whether it is divide the market, the world market, dividing the world market and have a pernicious effect on your market, then definitely your competition law can look into such kind of transactions. But if such the market allocations increasing economic efficiency and render market more more competitive, then these competition law provisions cannot be applicable. Again, if there is a restraint of trade, restraint of licensing agreement that affect parties in a horizontal relationship, does not necessarily cause the agreement to be anti-competitive in nature, not always, but you have to look into each and every case. Joint ventures, very well it is permitted, not always they are going to form cartels. So, the horizontal competitors, which always you can see that license agreement among competitors may promote rather than hinder competition, and which result in integrative efficiencies. That is why I said in the case of joint ventures, especially in the case of horizontal competitors, you have to look into the pro competitive effects. So, per se rule and rule of reason, we have to apply both the and look very closely into the type of transactions. So, the supplementary technologies and integrative technologies may increase the efficiencies as well. So, here you can see the market allocation, the courts very clearly said that market allocation, whether it is domestic in nature or international in nature, is absolutely violating the Sherman Act. This legal point is very clear. In the case of the supply management, so the many stores, you manage many stores in the country, you can have provisions with pro competitive effects. If there is, it is also with anti competitive effects, and then it is going to be violation of the Sherman Act. You cannot put highly restrictive provisions in the licensing agreement to divide the geographical market, then it is a violation of the Sherman Act. There is a restraint of trade, and you are not allowing anybody to enter into the market, which is a violation of the relevant provisions of the Sherman Act and Clayton Act. So, the application of per se rule and the application of rule of reason, which gives the competition authorities to evaluate if there is any chance of justification, the pro competitive nature of their activities. If it is pro competitive in nature, if it is not anti competitive, then there is no application of the Sherman Act in the United States. Moreover, we discussed the extraterritorial application of the Sherman Act, what the court held. So, if there is any effect in the United States, then there is an application of the Sherman Act. So, we will continue with the market allocation in the next class. Thank you.